Well, good late morning, everyone. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels, and as always, when we get things started in the mornings, we're going back to that horrible world known as the JRC. Now, as always, folks, before we get started, the link to the document you are seeing in front of you right now is going to be linked in the description box, as well as other pertinent links to the Stop the Shocks campaign. Most important right now, the templates that you can fill out and send to your senators to stop all federal public funding of the JRC. Number 2, also important, the Change.org Shut the Judge Rotenberg Center Down petition. These are slippery bastards, folks, who've been buying themselves out of trouble ever since 1986. That is in spite of 6 people who are now dead due to them. They can try to dress it up all they want, but that was not natural causes. Read on the 6 victims who have died while in their care. Now, warning, when we are talking about the JRC, we are speaking about we are giving vivid descriptions of, as well as sometimes showing video clips of video surveillance of people with disabilities being tortured and abused. If you have young children present, please wear your headphones. So, folks, this article was coming to you that is going to be courtesy of Ms. Linda Brown, also known as Autistica Hoya. You will see a link to her archive on all these articles and testimonies on the JRC. Please visit her website, spread this information, especially the testimonies and the coverage of the 2012 trial of Cheryl and Andre McCollins versus the JRC. Now, without further ado, folks, yes, you really are seeing on my page what you think you are. This is from the United Nations General Assembly that took place back on March the 12th, 2013. Now, this is coming from the Human Rights Council. Report of the Special Rapporteur on Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment by Juan E. Mendez. Now, this document goes through country by country, and you're going to find the United States, yes, we made the grade, folks, on page 84. So just remember this wonderful little thing I'm getting ready to show you here. The next time you hear one of those media bastards just trying to say, well, advocates say, no, honey, this involves the UN. It involves the world stage. But moving on, so we are going to page 84. And yeah. I was going to go directly to 84, but I want you to show you who this document was from. All right. Here we go. Here is the United States of America. A. Alleged mistreatment with electric shock of children and young adults enrolled in the residential program of the Judge Rotenberg Center in Canton, Massachusetts. Imagine the fact that the UN listened to us enough and felt concerned enough to conduct their own investigation into what was going on at the Judge Rotenberg Center. One school garnered the attention to the UN. Yes, we sent letters, but think about it, folks. What are the chances? It was a Hail Mary that it's still astounding to me today it actually worked. So, this is the report. The special rapporteur thanks the government of the United States of America for its response dated January 2nd, 2013, to this communication concerning the treatment suffered by the children and young adults enrolled in the residential program of the Judge Rotenberg Center, JRC, including the use of aversive therapy by means of electric shock and physical means of restraints. In its reply, the government reports that the JRC uses the Graduated Electronic Destillators, GED, to deliver contingent skin shocks as a form of aversive behavior control, including two versions of the GED, namely the GED 3A and the GED 4. Thank you, UN, for doing your damn homework. That are modified beyond what was approved for use by the United States Food and Drug Administration. Thank you! The government explained that the FDA has sent a warning letter to the JRC on December 6, 2012, demanding prompt corrective action as regards the use of the modified GEDs and requesting a meeting to discuss discontinuing their use. The government has also reported that the use of aversive therapy by the JRC has been challenged to a variety of state and federal legislative and judicial actions, including the Department of Justice investigation into possible violations of civil rights laws, which remains open and ongoing. Can you believe this? All this was going on. We're talking all the way back in 2013, right before the FDA trials started going on. All of this, all that the UN is revealing right here from this specific office, and they had the balls to overturn it. Yeah, this is why I'm saying this is not just a small case, folks. This is on an international stage. In this context, the government reiterates that it would gladly provide additional information once that investigation is complete. In Massachusetts, a variety of measures that would regulate or ban the use of aversive treatment have been introduced in recent years, but failed to pass into law. However, the Commonwealth of Massachusetts Department of Developmental Services, DDS, amended its behavior modification regulations in October 2011 in order to ban all schools in Massachusetts from using certain aversive interventions unless a child had a court-approved treatment plan that allowed for their use prior to September 1st, 2011. Because that makes it all right. If a judge orders it, the judges are never wrong, right? Between this and the freaking Depp case, my faith in judges is at an all-time low. The government additionally stated that in New York State, regulations have been enacted prohibiting all-day or residential schools from using aversive interventions, which also provide for annually renewable exemptions in cases of children whose state-minded individualized education plans approved for the use of aversive therapy prior to June 30th, 2009. Not far enough. Not far enough. Furthermore, New York authorities expect that by June of 2014, all New York residents at JRC, including those who remain subject to court-appointed aversive interventions, will be offered placements in New York State where such interventions are not authorized. So they did finally. God. The Special Rapporteur welcomes new information received, indicating that in February 2013, the state of Massachusetts announced it was seeking a reversal of the court order that approved treatment plans using aversive therapy. Although the Special Rapporteur appreciates the government's response, he expresses serious concern about the physical and mental integrity of the students residing at the JRC in view of a continued use of aversive shock therapy and physical means of restraint as part of the JRC educational program. He notes that although in 2011 the Commonwealth of Massachusetts Department of Developmental Services approved regulation changes that limited the use of the Level 3 aversive interventions, including skin shocks, this new regulation does still allow the use of electric shocks for those students who have an existing court-approved treatment plan as of September 1st, 2011. Under the revised regulations, only new students in Massachusetts are protected from Level 3 aversives, including electric shock or prolonged restraints. Thank you. The special rapporteur notes with great concern that many students at the JRC are still eligible for Level 3 aversive interventions, including electric shock treatment. The special rapporteur is also concerned that Massachusetts regulations would not apply in other states. The JRC, previously called the Behavioral Research Institute, was previously located in California and Rhode Island. There is nothing to stop the JRC from simply relocating again to another state. Go off, you in. I do not say that sarcastically. Go off. I'm going to love to see their response to this overturn. I'm hoping it's going to be a thing of beauty. There's nothing to stop the JRC from simply relocating again to another state. Protections are needed at the federal level to ensure Level 3 aversives are brought to an end in the United States of America. Oh, damn! Let me read that again. Protections are needed. Hear what they're saying here. Listen to this. Protections are needed at the federal level to ensure Level 3 aversives are brought to an end in the United States of America. Okay, I'm sorry, but thank you. Somebody with a brain. The special rapporteur understands that under individualized court orders now in place for the JRC patients, the use of Level 3 aversive have been justified as a form of treatment, rehabilitation, habilitation, or education for persons with disabilities. The special rapporteur would like to draw attention to Mandate's recent report on the applicability of the torture and ill treatment framework in healthcare settings. That was the 1st of February 2013. As the report states in paragraph 18, authoritative interpretations of international human rights law by international bodies have established that a violation of the Convention Against Torture may occur where the purpose or intention of the state's action or inaction was not to degrade, humiliate, or punish the victim, but where this nonetheless was the result. Oh, they intended. Read the fucking testimonies of those victims. Don't tell me they had the best intentions. Bullshit. The report calls into question the concept that medical necessity may ever be used to justify a treatment practice that includes severe emotional or physical pain. This is particularly the case when intrusive and irreversible non-consensual treatments are performed on patients from marginalized groups, such as persons with disabilities, notwithstanding claims of good intentions or medical necessity. Paragraph 32. The special rapporteur reminds the government of paragraph 7A of the Resolution 8 of 8 of the Human Rights Council, according to which corporal punishment, including that of children, can amount to cruel, inhuman, and degrading punishment or even torture. The special rapporteur further reminds of his report to the 60th session of the General Assembly, in which he determined that any form of corporal punishment is contrary to the prohibition of torture and other cruel, inhuman, degrading treatment of punishment, and the states cannot invoke provisions of domestic law to justify violations of their human rights obligations under international law, including the prohibition of corporal punishment. The special rapporteur also reiterates that in paragraph 5 of the General Comment number 20, the Human Rights Committee stated that the prohibition of torture and ill treatment must extend to corporal punishment, including excessive chastisement ordered as punishment for a crime or an educative or disciplinary measure. Therefore, and in the absence of evidence to the contrary, the special rapporteur determines that the rights of the students of the JRC subject to Level 3 aversive interventions by means of electric shock and physical means of restraints have been violated under the UN Convention Against Torture and other international standards. Woo-hoo-hoo-hoo-hoo. Let's read that again. I want this to sink into you. This is how big of a deal it is. Think about this. Okay, let's say it again. Therefore, and in an absence of evidence to the contrary, the special rapporteur determines that the rights of the students of the JRC subjected to Level 3 aversive interventions by means of electric shock and physical means of restraints have been violated under the UN Convention Against Torture and other international standards. Boom! Mic drop. Mic drop. There's my argument. Thank you. The special rapporteur calls on the government to ensure a prompt and impartial investigation into these continued practices. He calls on the government to provide information on the Department of Justice investigation into possible violations of civil rights laws and to take measures to prohibit the use of Level 3 aversive interventions for all students on a national level, including those students who had an existing court-appointed treatment as of September 1st, 2011 in Massachusetts. This makes you wonder, doesn't it? Makes you wonder how that D.C. Circuit Court had the balls to overturn the ban when you have this right here from the UN. They were already flirting dangerously with the line there. They were already flirting dangerously with the line to be condemned as a country that condones torture, that would have been violating that particular treaty. And then to have the DC Circuit Court do what it's done? Yeah, folks, this is serious. And it's not just serious because of what's happening to those kids. Think about this now from an international scale. Okay? All right, moving on. Okay. I think. Okay, so that covers it in regards to the JRC. But I found it particularly damning. And it just makes me wonder what the hell the DC Circuit Court was thinking. And do they have any idea what it is they have done? Like, do they assume that the special rapporteur on torture has simply forgotten all these things? Because I promise you, my friends, they have not. They have renewed time and again about independent investigations to be done in regards to this, and federal laws to be passed to prohibit it since the goddamn Bush administration. This has been said again and again and again. And look what they said. Let's go back to it. I want you to think about this on an international scale as well. What the DC Circuit Court has done. Hear this sentence and think about it. We're going to go to that last paragraph there. Okay. Therefore, in the absence of an evidence to the contrary, the special rapporteur determines that the rights of the students of the JRC subjected to Level 3 aversive interventions by means of electric shock and physical means of restraints have been violated under the UN Convention Against Torture and other international standards. By the DC Circuit Court doing this, they are putting us in the violation of the UN Convention Against Torture. Yeah. By doing this, we are in violation of that convention. The United States. That is what the D.C. Circuit decision on July 7th has done. It has put us in violation of that convention. Think about the repercussions of that. I'm just saying. Folks, my part in this is I want those kids free. I want every student out of there. I want that place closed down and burnt to the ground and its ashes to be used to spread around, or perhaps put in a bowl and put on display as a warning to others. But this is much bigger than just us advocates. The JRC tries to tell you that it is, oh, it's media spin, even if the media seems to be largely on their side. It's not what people really say it is. Look at this. This is big, folks. This is international scale big. And that's my final thoughts on that, folks. The D.C. Circuit Court has put us, the United States, in violation on the UN Convention Against Torture and other international standards. Think about that. All right. So there's going to be a few more videos out, of course, as it is my weekend, but I'm going to go ahead and close out this one by saying, as always, we don't get very many views on this channel. The few that we do get do tend to get removed from time to time. So folks, please don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. I do appreciate your time this morning, and as always, we here at Spilling Tea hope you have a good one. Bye-bye.